about who I am and then pass it over to Ashley. So welcome everyone to Cal State Fullerton Startup Incubator's guest speaker series. We're doing this every other Wednesday at noon, and today's speaker is Ashley, and she's going to be talking about contracts that all startups need to know and some of the legal matters. She is a business attorney, and before we hand it over to her, I'll let you know a little bit about us. If you found us on Eventbrite and you're new here, welcome. This is, again, as I was mentioning, something that we put on in addition to our weekly, or excuse me, our bi-monthly events. We really focus in on helping the startup at the ground floor. We help them from the early ideation phase all the way through to getting the product out, and then the ultimate goal would be to bootstrap and get it into revenue. But we can also help you seek funding and help you with the investor pitch deck and you know, the hunt for so-called Shark Tank and getting it out there. So anyway, we help you with what's called the Lean Startup methodology, and we help you for 6 months. We find that that's actually a pretty good amount of time to help people, and we offer this service on a tuition basis. It's not a we don't take any equity in your company at all. So we're here to help you. We're here to teach you about how to run businesses, and that's kind of our main focus. And we want you to be successful. And then your success is our bragging rights. So that's what we're here for. All right, I'll put more information in the chat, but that's enough about me, and I'm going to hand it over to Ashley. So Ashley, why don't you go ahead and introduce yourself, and feel free to share your presentation and take it from here. Thank you.
Like Philip said, I'm going to talk about business contracts that not only should you be aware of some of the details of them. I'm not going to go super detailed into everything because, like I said, we would be here all day, but it should be enough to introduce you to the concepts, the ideas, what you should look for, and then we can go through specific questions. So about me, I'm a senior associate. I'm an attorney here at Cummins & White. It's a law firm in Newport Beach. We focus on essentially everything that a business owner could need. So I focus on transactional. So that's mostly contracts, mergers and acquisitions. So selling and buying businesses, some securities work, trademark filings, in general business advice. I've been an attorney for over 10 years. I've been here at Cummins & White for just over 5 years. And we also have here litigation attorneys that focus on business litigation, insurance, employment, tax, and real estate and estate planning. So we try and be a well-rounded firm for our clients, our business clients. I am also a second generation transactional attorney. My mom is also a business lawyer. She focuses primarily on securities, IPOs, PPMs. So, you know, on the public side. All right. So I wanted to focus today on sort of going through the basics of what a contract is. I think sometimes we lose sight of the very basic parts of this these foundational documents, and we start to either not understand when we need an agreement or a contract and when we don't need one and what it consists of, why we need it. So I like to start with this little overview of what a contract is. Oh, and by the way, if anyone has questions while I'm speaking, feel free to put them in chat. I can't see it right now the way I'm presenting, but Philip, if you want to stop me for questions, that's fine. I also will have time at the end for questions. Okay, so this is kind of your foundation. Negotiating a contract is a collaborative process between the parties, not a confrontational event. Sometimes, you know, people can confuse litigation and transactions. On the transactional side, with an agreement, we're trying to get to a midpoint. We're not trying to go in opposite directions. I want X and you want Y. We both want X. So it's helpful to keep that in mind, that we're working together to get somewhere. And yes, we may disagree on points, but we're still trying to get to the same place. So what's a contract? Let's start very, very basic. This is your law school definition. I will have a normal definition in a second. But these are kind of the 3.5 points of it. One, that there's an offer. 2, that someone accepts that offer. And 3, that there's consideration for that agreement. So in this example, I would love to sell you 100 widgets. You would like to buy my 100 widgets for $100. Okay, that's a contract where we're looking to get a meeting of the minds. You understand what you're getting, and I understand what I'm getting. You're getting 100 widgets. I'm getting $100. So that's the foundation. And I think you know, you can read this useful definition. It's just a binding agreement that sets out the terms and obligations between the parties. So we want to know who the parties are. I think this is on my next slide. Who the parties are and what they have to do. So why do we need a contract? There's a lot of reasons. I think we're all familiar with the game of telephone, where someone says something and it gets passed along, and the whatever you said comes back to you, and it's not what you said. That can happen when we're agreeing to contract to goods and services. So we want to make sure that each party knows what their rights and obligations are. So what do you get and what do you have to do? It also offers legal protection in the event that something happens where one party doesn't perform. We can take that contract and go to a judge and say, hey, we agreed to this. The other party didn't perform. We want to be made whole. So there's a couple of reasons, and you know, a critical one, ensuring you receive payment on time, and it helps maintain good relationships between the parties because we each know what we have to do. So some of the reasons on why we need a contract, and when you need a contract, is for these purposes. So what are we trying to accomplish in an agreement, in a contract? I mean, I've said this a couple times, but accuracy in the parties' rights and obligations, but stated as simply and clearly as possible. So, you know, people talk about legalese. I try to avoid that as much as possible in agreements that I draft, and you should seek to eliminate it from any agreements that you're negotiating. It just makes things more confusing. There's no reason for it. We can use plain English and have success with that. Something else I like to bring up, a fair agreement. I don't go into agreements that I'm drafting with the goal of obliterating the other party. Like I said, it's a collaborative negotiating process. If I put a bunch of terms in that are wholly unfair to the other side, either we're not going to get the deal done, which now I haven't done my job, or we're going to rack up legal fees by going back and forth on terms that aren't market. What's market is different in every market, hence the term. But usually the parties will know roughly what's fair, and if it turns out they're wrong, they'll generally be corrected, and that goes away in the next draft of an agreement. So yeah, you end up in the same position than if you had just drafted a fair agreement in the first place. And this doesn't mean you want to give on things anticipatorily, but you don't need to have every single provision of an agreement solely in your favor so dramatically that the other side really has nothing to do. So that's we're trying to accomplish, accuracy and fairness, so that, again, we know what we have to do and how to perform. I think that's important.
This is JJ. I love
Yeah.
that because having spent much of my career in sales related positions, one of the things that I would say is that, hey, no is an acceptable answer.
Yep.
So think about it. I mean, us not doing business, it's okay.
Yep.
But how about we come to some mutual understanding, right?
Mm-hmm.
And take the pressure off. And so even if there's no contract, as an example here, you have the chance to do business with them again. And then you can contrast that with the scenario where the objective seems to be to cut the legs off the other person. You know what I mean?
Yes.
And okay, that'll only happen once.
Yep.
So
If you're lucky, it'll happen once.
Right. So anyways, my kudos. So
Yes. Yeah. And I think it's important to remember, we're so used to an adversarial process just day to day that sometimes people go into negotiating an agreement in that position, in that adversarial position. And yes, you want to be protective of your rights and you want to make sure you're getting a fair deal. But if the other party's not getting a fair deal, they're less likely to perform, honestly. It's important to keep in mind when you're going into it, is it doesn't have to be adversarial. And it really shouldn't be when we're trying to get to the same place. All right. So let's talk about some specific startup agreements. And this may be repetitive for some of you, but we'll start at the beginning. So if you're setting up a company, you're at the point where you've tested your idea, whether it's goods or services, you're ready to go to the next step. You want to form a company with either a partner, multiple partners, or just by yourself to get some liability protection, again, to set out rights and obligations of the parties to each other. Where do you start? Well, we have to pick an entity type, and then we have to form that entity. So that's generally called formation documents. It's just a very general heading. And we can talk about entity selection if anyone is interested, but for each entity, and there's advantages and disadvantages, they all afford you some level of liability protection, and they all provide you with a roadmap to how to deal with each other internally and how to deal with third parties externally. So very helpful, relatively inexpensive. If you set up in California, you have to pay at least $800 a year to the Franchise Tax Board for the privilege of being a California entity. But initially, that's probably your total spend on sort of maintaining an entity. So if you're setting up a corporation, you have to set out your articles of incorporation. For an LLC, it's articles of organization. Delaware uses different language, but they're the same. And if you're setting up a limited partnership, certificate of limited partnership. These are all very, very, very basic documents. They basically contain the address for the company, your registered agent. So that's a person in the state of incorporation that can be served papers in case you get sued. So for my clients here in California, I serve as their agent for service of process. So that way, in case they ever get a lawsuit, someone's not, knocking on their house front door and serving them papers. They can come serve me at my office. We're used to it. So it sets out the address. registered agent. And if you're a corporation, it sets out your authorized shares. LLCs do not have authorized shares or authorized units unless they choose to do that. It's not required by statute. So that's the majority of what they contain. And then you will sign it, or if I'm creating an entity for someone, I sign it as the incorporator. And then you file them with the Secretary of State. Secretary of State approves them as long as the name isn't taken. And then we move to the next step. So next step. So governing documents.
So Ashley,
Yeah.
this is JJ, and there's a chat message from Alex. He wants to know which entity allows for hundreds of owners versus the entities that are best for smaller amounts of members or owners or shareholders.
Yeah, so if I was thinking about that many owners, I would be going with a corporation. LLCs I generally find the most useful for holding a piece of property. So not, you know, what the subject of the incubator is, but or a true small consulting business. Otherwise, LLCs get a little unwieldy with a lot of members. It's a little odd with the percentage ownership and how dilution happens. It's not as upfront. And also with an LLC, there's no option to stop pass-through taxation. With a corporation, you can elect to be an S Corp or a C Corp. An S Corp allows for flow through to the owners. So essentially you'll claim all profits and losses up to your ownership percentage on your personal tax return as an attachment. An LLC, you can never turn that off. So you will always have that flow through. And investors generally, especially outside of the real estate space, do not like that, because you can run into a thing called phantom income, where essentially you get taxed on profits that the company made, but were not paid out to you. So if you're looking for many, many, many owners, it's a little more organized to have a corporation rather than an LLC. So that's what I would recommend.
Thank you very much.
Yes. Okay, and so that actually goes into the governing documents. So operating agreement, bylaws, partnership agreement. They all essentially do the same thing. They set out the rights and responsibilities of the owners to the management and third parties. These documents can be very complex or very simple. It really depends on what you're trying to achieve. If it is an LLC that holds a piece of property and it's just a husband and wife that own it, you're going to have a very simple operating agreement. There's not a ton of issues to go through. If, on the other hand, you know, Alex is talking about a corporation with hundreds of owners, your bylaws are going to be much more complex. We really want to set out what are the roles and responsibilities of everybody involved. In a corporation, you have officers and directors. We want to know, one, I mean, who they are, but what their responsibilities are, and how do we appoint them? How do we have meetings? There's a lot that goes into the structure of corporate bylaws. And that's just to make sure that everybody knows what they're supposed to be doing and what to do in the event a situation comes up that they weren't expecting. You know, someone resigns as an officer. How do we appoint a new one? What is that process? The bylaws will set it out. We have to have a meeting. How do we tell people? The bylaws set it out. And an LLC is very similar, an operating agreement. So an operating agreement will have all of those things. It's a little less onerous because there's only 2 levels of people in that company. So you have members and you have managers. Managers are essentially officers and directors rolled into one, and members are shareholders. I hope that's a helpful comparison. And then I want to talk about a shareholders agreement, because it really follows into these governing documents. It's just a specific document where bylaws are really focused on the management of the company. But what happens, say you have 4 shareholders and someone wants to sell their shares in the company to their brother. Without a shareholders agreement, that person can just undertake that transaction. There's compliance with securities laws, but for all intents and purposes, they can sell their shares to their brother. But what if the other 3 partners don't like that individual and don't want them, the selling shareholder, to sell their shares to the brother? Can we stop that? Well, if you have a shareholders agreement, that allows for the administration of what happens when someone wants to leave. That's essentially what it is. So how do they sell their shares? Who do they have to sell it to first? Usually that's the company. And then second, usually that's the remaining shareholders. And if no one wants to buy those shares, then that shareholder can sell to someone else. But it allows for a couple of bites at the apple for the company to maintain that closely held corporation that they started with. So they don't end up with, you know, someone's ex-husband as a shareholder, and now you have spouses that are in dispute as shareholders. It gets very messy. So I always highly recommend shareholders agreements for corporations with multiple owners. And then why don't LLC members need one? Those sorts of restrictions on transfer are in the operating agreement, or they should be, and how a member may sell their units or transfer them to maybe their trust or some other disposition of their units, and how that works. So highly recommend a shareholders agreement if you're setting up a corporation, especially with partners that you may not be as familiar with. So it's a good thing to have. I also highly recommend it for family-owned businesses, because as we all know, they can be the messiest sort of separations. So highly recommended for family-owned businesses as well. Okay, something else you're going to need at the outset is likely a non-disclosure agreement. And you should have this whenever you're disclosing confidential information to anyone. That includes, you know, potential employees, advisors, consultants, third parties. It's just one document that helps you maintain some confidentiality. So say you provide an employee with financials that have numbers that you wouldn't want a competitor to see, and then that employee leaves. If you had them sign an NDA, to the extent you're legally allowed to, then you know that that information is protected. And if you find out that it's going to be shared outside of, you know, the company, you can go to court and say, hey, we would like an injunction to stop this person from disclosing our confidential information. It's especially important when negotiating business deals. So if you are dealing with a competitor or with a vendor that works with your competitors, something important to make sure is in place. And it sets forth what is to be kept confidential, how long it has to be kept confidential, and what the exceptions are, and what you do in case someone does say that they're going to release confidential information. Okay, something that is probably interesting to most of you, equity grants. So you want to give yourself some shares or some units, and maybe you have a trusted advisor. You don't have cash flow to pay them right now, so you want to give them something of value, and hopefully that is an interest in your company. There's a lot of different ways to do this, and even within these, 3 examples, there's a million different ways to accomplish these goals. So the first and the most obvious and the easiest to keep track of and to handle is just a direct grant. So you just give someone shares, you just give someone units in your LLC, they become an owner immediately. You do have to treat them as an owner, so a shareholder or member. That means you have certain rights and responsibilities to them as owners. But again, very simple, easy to grasp. It doesn't have to be more complicated than that, but you might not want to do that. You might want to include some sort of vesting schedule. So instead of giving you 3% of the company today, I want to give you 1% in a year, and then 2% vesting over the next 2 years. That gives people an incentive to stay and work hard instead of showing up for a while and then bailing because they already have their ownership. And you can't take away people's shares or units once they are given. So you may be able to buy them out pursuant to a shareholders agreement or terms in the operating agreement, but you can't just retake them. So that's when these vesting periods are useful. If anything is not vested, generally that's sacrificed if someone leaves, or if you terminate them, or whatever else happens. Anything they've vested, they get to keep. So that's kind of the simple direct grant of equity option. There is, of course, stock options. We've all heard of them. It does require the company to create, it has to be a corporation. It does require the company to create a stock option plan if they want their stock options to be tax advantaged. That's a tax advantage for the company and for the recipient. It is a rather lengthy document, but it is mostly formulaic to comply with IRS rules. So this sets out how many shares can be issued pursuant to the stock option plan. There is a limit. You can always amend that, but it requires consent. That way people know how much ownership there potentially is floating around in stock options. It also requires an accompanying stock option grant document where you tell that person exactly how many options they're entitled to, what is the fair market value of those options, what they have to pay, the vesting schedule. All of that is in the grant agreement. And then you have to keep track of this. So that's the disadvantage of stock options, is making sure you're keeping track of who's vesting when, how many options are floating out there, what your ceiling is so that you know not to over issue stock options. But it's a great option, pardon the pun, for newer companies who want to retain talent generally. It's most advantageous to employees specifically because of the tax advantages. So another way to issue equity to owners, employees, and also consultants and advisors, although it's not as beneficial. LLCs cannot issue stock options because they do not have stock, and the regulations from the IRS do not allow LLCs to have the same sort of tax advantaged plan. So your other options for an LLC, there's more beyond this, but these are the main ones. One is obviously direct grants, and two is a profits interest. This can also be done in a corporation. Generally, it's similar to phantom stock. Basically, both of these mechanisms allow you to grant people an interest in the increase in profits of the company. So they don't have an ownership right. So they're not treated as a shareholder or a member. You don't have to include them at shareholders meetings or members meetings or in consents where you need the consent of the owners. They're not owners, but they do own a right to the increase in profits of the company. So this is very helpful for early stage companies where the increase in profits can be dramatic. You're probably starting at, whenever you're issuing these, a very low value for the company because it's startup mode. And then you hope that the value of those units increases, and that way that person gets a payout at some point, generally upon acquisition, but sometimes it's you can really make that threshold whatever you like. So those are a couple of different options for equity grants, and there's more, but generally this is where you're gonna start. So another good startup piece. Oh, something else that you're going to need is 2 agreements minimum for your website. Even if that's an app, even if that's software, even if you're offering different things, you need terms and conditions. Essentially, that is back when we were talking about our basic contract terms. It is a contract with third parties that applies to everybody. So you want to make sure that that includes your app users, software users. It's not just the people who click on your website. And that would be referenced in your app or in your software agreement, that the terms and conditions on your website do apply. Now I sound like an infomercial, but it's extraordinarily helpful. It is not legally required technically, but it would be a mistake not to have it. It basically can dictate where people can sue you, your limitation of liability. Maybe you can put a cap on what can be paid out, some indemnification, the responsibilities that the users have, what they can and cannot do. Mess with your software is one of them. So we want to make sure that that's all laid out so that we have an overarching agreement with all users. So terms and conditions, very important. And then a privacy policy. So this is legally required, and I'm sure you've heard enough about it. I don't need to go into nitty gritty, but you need to have a privacy policy that complies with state and federal laws regarding privacy. California has passed another law that has increased obligations of businesses on ensuring that users and third parties know what's happening with their data. So you can get terms and conditions and privacy policies through lots of different places online. I recommend that if you go that direction, that all of their documents are very up to date, because the privacy policy laws change a lot. They change frequently, and unfortunately they change dramatically. So those are documents that I create for our clients, but there's a lot of options, and it's just something that you should have from the outset when your website, software, app, anything goes live. So a good starter agreement for you. So that's what the bulk of my presentation. There's a little quote from Warren Buffett. It's impossible to unsign a contract, so do all your thinking before you sign. That's kind of what we're getting at, is think through the process. Think about what the rights and responsibilities of partners are to each other, to third parties. That's what you want in your terms and conditions on your website. Agreements with vendors, all of that. So, make sure you've thought through your agreements before signing them. Okay. And I'm happy to take any questions that anyone has at this point. I hope that was a good general overview of startup agreements for you.
Thank you, Ashley.
You're welcome.
You did a great job. Thank you very much.
Oh yeah, happy to share any information I have.
So feel free to unmute yourself and ask any questions you might have.
Yeah, I'll kick it off. This is JJ. One thing that I've encountered doing business with startups as an investor and otherwise is the variance that exists with those agreements state by state.
Yeah.
And the preferences that a state like Delaware might offer as an example. Could you comment on that?
Yeah, and I should have talked about this in the formation section, but I have a couple of key thoughts for startups when they're thinking about where to form a company, which is generally if you want to form your entity in the state that you're actually in. And that's my first general recommendation. And the reason why is if you form a company in another state, for whatever reason, you then have to qualify it in the state that you do business in. So if your office is here, or your home is here, and that's where you work, you'll have to qualify that business in California or wherever you're located. But it's one more expense. It's one more thing to keep track of. The exception I have for that is, one, if you don't live in California, you can form in that state. But if you are really focused on seeking venture capital funding specifically, or I would say like big time investor money, not a friends and family round, a lot of times they want to see a Delaware C corporation. And the reason why they want to see that is, one, Delaware has a special court for business disputes. So things can be heard faster than in a California court. Number two is Delaware laws are generally more favorable to business. So if an investor is going to come in and be an owner, they want to be able to take advantage of Delaware's laws that are more favorable to them. So it's something to keep in mind. I don't think everyone should run out and incorporate in Delaware. I don't think it's necessary for most businesses. But if your number one goal and your first thing you're going to do is seek venture capital or big time investor funding, then it's something that you should talk about with your lawyer or or that investor if you know who they are ahead of time. And there is a large variance in state laws about business contracts, about the duties of management to owners. So Delaware is generally more favorable in that way.
I had a question for you, please, ma'am.
Yes.
Could you initially form in a California corporation, but let's say you have some hyper growth or some real successful growth, and you have these big time investors. Are you able to just move the corporation to Delaware and reincorporate it there when the time comes? And also, we hear a lot in the news over the past 2-3 years about how Apple and these big companies incorporated in Ireland and in the Dominican Republics or these foreign countries to avoid profits. I mean, we're not there yet, but you know what I mean?
Yeah, so I'll take your first piece, and yes, you can it's called redomestication. You can redomesticate in another state. There's a couple of different methods of doing that, depending on what form of entity you have and what states you're dealing with. All that documentation looks a little bit different, but we do it relatively frequently, especially if someone moves. I'm based in California, so someone moves to Nevada and moves their whole business to Nevada. They no longer want to pay California tax, or not as much as they were paying. So we will redomesticate them in Nevada at that point. It happens a lot with Texas, and then it happens with my startup companies with Delaware when they bring in a new investor. I just did one 2 months ago for a company to redomesticate from Washington to Delaware. It's possible. It's a little bit of a process. It's not that complicated. Changing entity form is more complicated than changing where the company lives. So changing from an LLC to a corp, or the other way around, can have some tax consequences that we don't want. But just changing where it's located, not the most difficult process. And then the having entities overseas, yeah, I've dealt with that on some real estate holding deals, especially with foreign investors. It is rather complex and expensive. If you get to that point, it might be worth it. Obviously, initially, it's not going to be worth it. It involves hiring counsel in those countries and a very strong tax team to handle that.
Thank you very much. I appreciate it.
You're welcome. I could stop.
I might have some overall questions for you, kind of like next steps almost. Okay. This presentation was great and really helpful and kind of exactly what I was hoping for.
Awesome.
Does anybody here have recommendations for kind of a more in-depth content information about these things that's kind of aimed for kind of like beginner 101 audiences?
Well,
go ahead, Philip.
Yeah, so yeah, we definitely help with that in our incubator. That's kind of what we do. It's we're providing guidance as you're starting up a business. Ashley will definitely be the point of contact regarding any business type of legal questions. And so if you have a question regarding contracts or any of that sort, ask Ashley. But if it's something else in terms of the business, that's definitely what we're here for. That's what our incubator is set up for.
Great. Yeah, I was thinking more on the legal side, but I'll definitely look into y'all's incubator as well. But I guess maybe this might be too general of a question, but for kind of very small startups, do you have any kind of like general recommendations about like what is worth investing in a lawyer for? Like on these documents, and what's worth kind of like you can get away with templates and stuff for, bootstrappers like myself. Yeah,
so I would say the privacy policy, especially initially, I think you can get away with a high quality version online. I wouldn't just rip it off of someone's website because you don't know what they invested into it. I think that one is a go-to. I think on formation, it depends on your comfort with how many questions you need to ask. So if you need to really explore your different options, maybe you have a couple of partners or want to seek funding in the future, you might be better off with an actual lawyer like me. And if you want to talk after this, you can feel free to contact me. I do initial consultations for free. But if you're comfortable, you know what you want, and you just want to form, you could probably do it yourself, honestly. I think you can get good quality templates for a very basic setup online. I would just be careful as you add people, as you add owners, as you add managers, as you add consultants, all of these things, it makes your liability higher. And so the basic form documents that got you through the initial push are probably not going to cut it anymore. So something to think about, and it really depends on your comfort level and what stage that you're at initially.
Thank you.
I have an opinion there that I'll share, and that is the setting up the legal entity. That is just a very basic step, and the relationship with the attorney is ongoing, because that is, in the life of a startup that becomes a company, there are so many decisions where you need the help of someone like Ashley. So yeah, you can go to LegalZoom or whatever and get things started, but what's missing from that is Ashley's 10 years experience and the judgment that goes into many of these decisions as the company grows. So my advice is seriously consider working with the attorney.
I had a question for you real quickly. Sorry, for the attorney, of course, Ashley. When you're a small startup, and whether you're selling a small product, when there's IP involved, and it's brand new. I was reading a lot of the intellectual property books, or when you file your products for patent protection, you have the first year of protection as a simple filing, but then after the 12 months, you need to file something a little bit more meaty to protect it. Now, if it's a small shower head or something like that, those are, how often is it required for you to have right upfront counsel on that? If it's a simple, stupid kind of thing, but something like that.
Yeah, and I have to give you a caveat that I am not a patent lawyer. I'm not allowed to practice patent law because I did not take the patent bar, nor do I have a hard science undergrad degree. Sorry to disappoint everybody. But patent law is so specific and complex that I can't really comment on that too much. I can do trademarks, soft IP. Everything that I get that is patent related, I refer to a patent attorney who tells that person, hey, this is what you need to do. So
Thank you very much.
Yeah, I would recommend, at least most transactional attorneys, patent lawyers will give you a free consultation so that you can say, hey, here's where I'm at. Here's what I'm looking to do. Do you think I need to do X, Y, or Z? And they should be able to tell you. And if you want a referral, you can feel free to contact me, and I will provide you with a referral.
Thank you.
Yeah, Alex, we have a patent attorney that we're actually going to have as a guest speaker. His name's Justin Sanders. He's worked with a lot of our startups in the past, but I'm sure Ashley would also be a great resource as well for always get another opinion. But we can definitely connect you with a patent attorney.
I appreciate that, sir. Thank you very much.
Yeah.